What is your, do you have a suggestion or request?
Well, I think if you're charging two, another capital felony there with a battery, it's actually not charging about an injury capital felony. Which is one of the matters that we led. Follow that. I don't believe that language in there after capital felony is appropriately charged. My understanding, that would be pretty much, since you found guilty of aggravated assault, then there definitely is an aggravated battery. I'm not certain that's correct. So I guess I'd find some caution to strike that language.
And exactly what language? Please.
Act on the second paragraph, in the second sentence, after the phrase bodily injury to non-political capital felony, period, after that, everything, phrase, and the offenses of aggravated assault with a weapon, going on down to the in there, would be, I think it should be struck all the way to the end of that sentence.
Beginning where again, please?
Beginning after capital felony, which is at the end of the line, the third line of that second paragraph on page 3.
All right.
Going all the way to the end of that paragraph. That's just mine. In addition,
Looking at your notice of intent to seek the death penalty,
yes, sir.
that's where a lot of this language comes from. How do you suggest we connect paragraphs 3 and 6?
Well, I think the jury would just have to make a separate finding. I'm not. I think you just simply, another capital felony or aggravated battery, disconnected and charged with offenses kidnapped, bodily injury, there is a capital felony, period. I guess you would define aggravated battery at that time, perhaps. Frankly, I have court over that particularly.
page 2, the last sentence, where it states, under the law of this state, comma, add the word contends. So it reads, under the law of this state, under the law of this state. Strike the first part. And state as follows. The state contends the following may constitute statutory aggravating circumstance. Then leave paragraph 2 of page 3 as it was.
I'm sorry, what, paragraph 2?
What you were suggesting strike with changing, adding contends on the first page.
Yes, sir.
Leave paragraph 2 as it was.
Without striking any language?
Yes, sir. That's my suggestion. Now, this is not, this is a preliminary charge.
I understand.
And let me propose this language. Still on paragraph 2 of the third page. You with me?
Yes.
I'm going to read the whole paragraph with revisions. Where the offense of murder was committed while the defendant was engaged in the commission of another capital felony or aggravated battery, in this connection, I charge you that kidnapping with bodily injury of John Brooks is a capital felony. The state contends that Elmer Buddy Christian suffered an aggravated battery, period.
It's in paragraph 2, sir.
Yes. objection to that? Does that clear up your issue?
I think it helps, but I believe we ought to track the language in our notice number 3. State intends that the offense of murder set forth in counts 1, 2, and 3 that the indictment was committed while the offender was engaged in the commission of aggravated battery against Officer Elmer Buddy Christian. And it would also state further that the offense of murder set forth in counts 1, 2, and 3 when the indictment was committed while the offender, Jamie Donnell, was engaged in the commission of aggravated battery against Officer Tony Howard. I think rather than saying the state intends that there's an aggravated battery on Officer Buddy Christian, we would look into that. It'd be better to do that, track the language somehow, but it would just be simply after that first sentence, second sentence of by the injury to capital felony period, just define aggravated assault at that time. I mean aggravated battery, aggravated battery at that point, and do the complete definition of aggravated battery. Page 4, I think we only have a partial definition of aggravated battery. Language, offense, murder, and all aggravated battery, and my bodily harm will be occurred before death.
Anything else, Mr. Walton?
Yes, sir, Judge. I think the definition of aggravated battery is not complete.
What do you suggest?
Commits the offense of aggravated battery to he or maliciously causes bodily harm to another by depriving him of a member of his body, by rendering a member of his body useless, or by seriously disfiguring his body or a member thereof.
You're looking at page 4, middle of the page.
Yes, sir, Judge. I think that's not a complete definition of aggravated battery. We have the part about rendering a member of his body useless, and not the first part of depriving him of a member of his body by rendering a member of his useless. We don't have that. Right. And then we have seriously disfiguring the person's body or body part. I don't think body parts in the statute not as a member thereof. I think that's what that was aggravated battery. we had some stuff that we looked at, Judge, but I mean, we can certainly prepare some further. We have a
What's up,
kind of
Dan?
draft of doing that, but I like doing that. I did have some other matters to consider,
Okay.
that we're waiting on.
All right, go ahead.
One is, of course, in our notice, which may propose to have that go out to the jury, but of course, number 7 in our notice about this occurred while the murder of Ray Christian set forth in counts 1, 2, and 3 occurred while the defendant was engaged in conditions of capital felony armed robbery against John Brooks. That one, of course, would not be applicable at this point, as he was not guilty of armed robbery. So I would not expect that to go out to the jury. Of course, we would prepare a review those pages of the notice and have a redacted version without that particular one in there, that you're clear that they would not consider that as the subject.
Any objection to that, Mr. Hood?
No, sir.
Okay.
And in addition, Judge, I had sent to you and sent to Ms. Sullivan the redacted victim impact statements there, and as well as to Ms. Herbert and Ms. Hamilton, that I have a copy that was sent in alphabetical order. If you,
Status.
Mr. Jones had those, I don't know if Ms. Sullivan brought it to him. I have a copy for it.
She said she sent them, but I didn't receive. I just looked over now. I don't big deal.
We followed the order, but also we followed what we had notes from, and I think there's more redacted in the orders I indicated. Further, the defendant indicated that he was desiring to call and maybe change his mind of Debbie Gunning. Indicated all those reports of service, they blew it back because all those reports had not been served. I think you had the initial report from August of 2012 where Karen Bailey Smith, you might know this, Karen Bailey, Debbie Gunning had completed the report, and prior to the competency trial at that time, we did have that. Called Your Honor for an evaluation in 2013. There was an evaluation completed dated December of 2013, if I recall correctly. And that was sealed by the court. We've never been provided a copy of that at all. And I raised that with Ms. Sullivan yesterday by email. She indicated she was only authorized to provide a witness list and not anything further at all. So we don't have that, you know.
And that's December 13?
Yes, sir. That was one that was directed to be sealed. It had not been unsealed. We had not been provided a copy of that particular matter.
Yeah. I thought during the interim review, he would question that, and I thought he gave it to him. I mean, that's what I thought the whole time. That's why I said he had both of them pretty much saying the same thing. And I knew we asked for a copy of both because I didn't wrote on mine. I found out during the trial that we can't write on stuff. So, yeah.
I will, and that's your only copy, is that right?
Yeah, I got these my only copies here.
Okay.
This is part 1, this is part 2, but it's 2013, December 12, 2013. This is August 29, 2012. So I have them, but they written on, and I don't think I can introduce them if it's written on from what I learned during the trial, so.
And you do intend to call her, is that what you're saying?
Yes, sir. That's why you're on the phone. This don't look like it wrote on this after all. So you want to?
Is that the December 13?
Yes, sir. December 12, 2013 report. And matter of fact, it's not wrote on Dr. D. Gunning, Deborah Gunning, and Caleb Bailey Smith. Okay, so if they want to make copies of these, they go with it.
We'll need time to review those. Chance to do that. Obviously, before anybody called along those lines, we could have time
would ask you, unless you want me to keep the one written on, I wrote on it part one.
Make it 3.
I mean, this is August 29th, 2012, I wrote on it, I don't know if I have.
We have not.
They have that.
Yeah,
So, I mean, so it wouldn't hurt me, why do you think I can need me?
Your Honor, the jurors are along at the door.
Say again?
They're knocking on the other side, some.
Okay, ask, you can ask if they've got a note or something.
No.
Okay.
No response.
And,
They're just knocking on the door.
in addition, Judge, as far as, Mr. Keehan, who's, for the DMC, capital Keehan. This is the information that we have. He was in, first 2 weeks of July, he was in Colorado for fire training. Last call by the defense sometime between the 6th and 10th, they said it's time to record. He indicated that he was in Colorado, would be home for 1 day, and then would be leaving for Mexico. Told him he would not be back until the evening, late evening on the 23rd. And apparently the investigator told him that he understood. It was not, with him, he has not heard from them since then at all. We had spoken to him, his flight, he was supposed to be flying back in to Georgia from Mexico on the night of Thursday night, 23rd, as he indicated when before. We actually contacted him. It took a little while to do that as a cell phone service where he was at. But made contact with him yesterday, and he, before, I believe, in the evening. And he tried to change his flight at our request to leave Wednesday. And he was not able to do that. He tried to do that. So his flight, he's supposed to come back in Thursday evening with the available Friday. He had a pre-op appointment, his pre-operation appointment that was scheduled, but he had moved at our request to be able to do that. I wanted to let you know about that. That's the person that the defendant wishes to call and those efforts that we made. And he had not heard from them at all since they called between the 6th and 10th of July. What we're getting from him, back and forth by text or otherwise, I think. Again, it took us a while before we were able to even get in touch with him to do that. But he did try to make arrangements to change the flight, to leave sooner, to leave tonight. He's not able to do that. He will not be flying back into the country, in Georgia, until Thursday night, available Friday morning. I'm going to alert you of the scheduling matter. The defendant wished to call him, and we made those efforts to make sure that he was available at that time.
Anything else that you can take up?
I don't believe so.
Mr. Bud, anything else that you need to take up?
I mean, I don't do so much, I done told him I wanted him, I can't do nothing after that, my position on that, what can I do? I would like to get him in here, so. And, I'm counting these victim impact statement, I might have to say something about, the number, so I'd like to count them up right quick.
One, two, state and one to Mr. President.
yesterday at 5:06 from the prosecutor. I'd like to just state for the record, it's really excessive, it's 19 of them. I think that's excessive for victim impact. That's outrageous number of victim impact statements. So I'd like to just subject to, for the record, that's to the necessity of the amount of victim impact statement that they are trying to use here. So I just objected for the record, for the amount of 19. I just feel like that is too much overkill. So,
The objection is noted. I recall that we took that up
Yeah.
also at the time, and of course you objected then, I understand it. Court noted that we had several victims, and that was one reason for so many victim statements. Your objection is noted, correct?
all right.
But I'll tell you, while we're on that subject, I am going to ask if the state still intends to introduce the statement of Melinda Willis.
No, Judge.
Okay,
Never lumped into it, not really intended to.
all right.
And Martha Roberts, as I understand, is not going to be introduced. Carter Green is out of that.
Okay.
So those four I do not expect to.
Okay. Well, Your Honor, is there a possibility I can have a brief reset with her while y'all go over this about these statements? On litigation special. I just got it. I mean, I don't know how you want to handle it, but.
Well, there will, I'm not sure when, let's take one step at a time, and I don't know what order, if the state, we're getting into that, and when he's
We
calling,
intend to start with
all that.
Yes.
First. Well, let's figure out about this charge first, and then I'll give you some guidance to do that. All right? Did you see the changes?
Yes, sir, Judge, I believe that.
Mr. Hood, you have a copy as well. There was one phrase that was left out of the aggravated battery that supported by this evidence that's in there as
Well,
well.
the only thing I talked to that had that in there about the Amari Ray, the aggravated battery against Amari Ray.
Number 3,
Yes, sir. Defense of murder. I think also contends that defense of murder against Amari Ray occurred while the defendant was engaged in conditions of aggravated battery against him. Trying to put those together in that manner. And I think it's correct in regard to Buddy Christian, but we also have to add language about Jennifer Monterey, because that was alleged in our notice that's set forth in 10 and 11, paragraph 10 and 11 of our notice. Oh, I'm sorry. I think that covers, I think paragraph 3 on page 3 covers what's set forth in our paragraph 4 and our paragraph 11. If you're dealing with paragraph 2, you're involved in our paragraph 3, paragraph 6, as well as paragraph 10. And I don't think paragraph 10 is included in the page 3, paragraph 2. It doesn't include Kenneth Monterey that was occurred while the defendant was engaged in aggravated battery against Kenneth Monterey.
It's got or aggravated battery of the victims, of which Kenneth Monterey is one of them.
Yes, but you've indicated under B7, the murder was outrageously or wantonly vile, inhuman, so forth, that involved aggravated battery. But under B2, it basically has a separate notice if somebody's engaged in the commission of an aggravated battery, which is what you've got in paragraph 2 in regard to the death of Buddy Christian occurred while the defendant was engaged in an aggravated battery against Elmer Buddy Christian, while they was engaged in an aggravated battery against Tony Howard. But I think you have to also add language in there that's set forth in our notice, paragraph 10, that he was engaged in the death of Kenneth Monterey, and the death of Kenneth Monterey was committed by the offender, Jamie Donnell Hood, while he was engaged in commission of aggravated battery against Kenneth Monterey. So we don't have that included in paragraph 2, and I think that language needs to be included. Something to the effect the state also contends that the murder of Kenneth Monterey occurred while the defendant was engaged in commission of aggravated battery against Kenneth Monterey. Period. I think that sentence ought to be added in paragraph 2.
I'll make a notation for the record that paragraph 3 of page 3 also covers 17.1, 1710 of 3B2 as well as B7.
But I would contend it does not, because you're alleging that was one where it said the murder was outrageously wantonly vile, involved aggravated battery. That's a different statutory aggravating circumstance than what's set forth in B2.
Here's what I'm going to ask you to do, Mr. Marlin.
Yes.
If you will go back with your people and make that change here,
Yes.
that would be helpful while Mr. Hood looks over his statements. All right, and we'll be waiting.
Yes.
Thank you. So you can, while that's going on, you can meet with Ms. Sullivan.
That's what I was going to ask him to go to the office while he do that. Okay.
not gonna spend the morning on this.
Yes, yes,